Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. And specifically, this is the weekly recap from all the top stories from April 15th, 2024 throughout the week, all located in one convenient location for you. I hope that you enjoy it and have a wonderful weekend.
All right, lawyer.
Richard Allen's attorneys want to block his interrogation. That's right. The attorneys for the Delphi murder suspect, Richard Allen, are asking the court, that's right, Judge Francis C. Gull, to don't allow jurors to hear a recorded police interrogation, claiming Allen is claiming that he was never advised of his Miranda rights during his interrogation. Now, the request to block the recording was filed yesterday. And obviously, if you've been following the story, you know that Richard Allen was arrested back in October of 2022 and charged with 2 counts of murder in the 2017 slaying of 13-year-old Abigail Williams and 14-year-old Libby German. Now, the Delphi, Indiana man has pled not guilty to all charges, and we have a trial coming up just next month. Now, the attorneys are also saying that Mr. Allen's civil rights were violated. The attorneys claim that the Indiana State Police officials lied to Mr. Allen during the process of his interrogation. And according to court documents, they claim that either a camera was turned on minutes into the interview or the beginning of the interview was edited out. We'll have to wait and see how that turns out. I'm sure it was just faulty equipment or we forgot to start the recording. That's what they always say. And I don't know what went wrong. I'm being a little facetious there, ladies and gentlemen. So don't say, oh my God, Scott, you're so biased. Oh my gosh. Now, I don't know. I'm just telling you, I've seen over the years too many times where stuff's got erased, where it's been exculpatory for the defendant. Now, I'm not saying that took place in this case. I was just being facetious. So relax. Anyway, both of Allen's attorneys write in their filing that in their 70-plus years of combined experience, they believe that this is highly unusual police behavior. And they also said that Mr. Allen was held in this small, windowless interrogation room for over 2 hours without being allowed to leave. Now, like I said, this trial was supposed to begin in October, but now it's scheduled for May. So let's see, what is the issue here framed out? We all know, because we are avid Crime Talk aficionados, you only need to be advised of your Miranda rights when you are in custody and you're being interrogated for the incident that has you under arrest, okay? So then the police have to come in and give the standard Miranda advisement. You understand that you're under arrest. You have a right to remain silent. Anything you can and will be used against you. And you have a right to a lawyer. If you can't afford a lawyer, we'll get one for you, okay? And I've never seen anybody actually request that attorney, like, I can't afford one, but can I get one? And the cops are like, oh, gee, I don't know. He lawyered up. Let's just leave it at that. Anyway, so that's what you have to do. In custody and being interrogated. The issue is that Mr. Allen is alleging there were some misrepresentations that were made that are not on the video. Now, who could that help? Well, it could help Mr. Allen because he could say, this was promised to me and it's been deleted. Makes the cops look bad. If it was made or they didn't make those representations, you think you'd want to get that or reiterate that on the video. Now, I don't know what the truth is here. I don't know. I wasn't there. The court will have to make the decision, but remember, this is in front of Judge Francis C. Gull, who has denied just about every motion filed by the defense. She hates the defense attorneys. She does not like Mr. Allen, and she loves the prosecution. Anyway, it is what it is. We'll have to wait and see if she sets it for a hearing. She has to set it for a hearing because it involves the deprivation of one's potential liberty, and they've raised a constitutional issue. The government now has the burden of rebutting that allegation by clear and convincing evidence that there was no torture by keeping him in the room, confined with small windows. All those questions will be asked, and the prosecution will have to explain that this is not unusual. There were no threats. No one had their hands on their weapons or anything along those lines. They didn't beat him with a rubber hose, nothing along those lines. Prosecution has to show that by clear and convincing evidence to overcome the indication that these statements of Mr. Allen were obtained in violation of his Miranda rights. Next on the docket, Scott Peterson. Very short court appearance, and I mean short court appearance. He appeared in court to, once again, try to overturn his conviction for the killing of his wife and unborn son. Now, the lawyers for the L.A. Innocent Project, and in no way connected with the National Innocence Project, began representing Scott Peterson to have details that have been sealed regarding the ongoing case. Now, the hearing only lasted a couple of minutes because they determined that what they were asking to be sealed had already been sealed. So needless to say, there wasn't a whole lot to do. But Peterson's new attorneys are claiming that a van found on fire a day after a burglary near the Petersons' residence had a bloodstained mattress in it that could be related to the alleged murders. The van was found about a mile from the family home, and the LA Innocence Project also claims it has evidence that the van did not have a mattress in it before it was stolen and before Laci Peterson's slain. Now, this nonprofit is arguing that Peterson's rights were violated as evidence will prove his innocence and that this exculpatory innocence was withheld. For those who aren't familiar with this case, because it is so old, Laci Peterson vanished on Christmas Eve in 2002, a month before she was due to give birth. The prosecutors alleged and proved that Scott Peterson strangled or suffocated his pregnant wife before then wrapping her in a tarp, fastening her to anchors, and dropping her body in the San Francisco Bay. Now, Scott Peterson, who claimed he was fishing in Berkeley when his pregnant wife vanished, was ultimately arrested in San Diego County and coincidentally had $15,000 in cash and appeared as though he was leaving the area. Now, Scott Peterson went to trial back in 2004 and was sentenced to death. However, the California Supreme Court overturned the death sentence in that particular case after it was determined the jurors who disagreed with the death penalty, but they were still willing to impose it if they were found to find that it was appropriate, well, they were being unfairly dismissed from the case, and therefore you had not a properly qualified death jury in that case. Therefore, the court reversed that situation. Now, there was also issues surrounding prejudicial misconduct after a domestic violence victim was put on the jury as well, but the judge dismissed that as basically didn't make a difference. So back in 2021, Peterson was resentenced to life in prison without parole, and later that year, the judge denied his bid for a new trial based upon the juror issues. So we'll continue to follow this case. Scott Peterson, who's now, I think, 51, will continue to be with us forever, I'm sure. But you know how I feel about post-conviction matters. Obviously, we don't want innocent people in prison if they didn't commit the crime. But at a certain point, it's got to be on the defense to come up with some substantial evidence to prove actual innocence of their client. So far, I've seen nothing that would lead me to believe that they got the wrong guy in the Peterson case. But hey, if you think I'm wrong, let me know in the comments. And the Bryan Kohberger's attorneys have had to produce their notice of alibi. And what did they say? They said that the cell phone data will show that Bryan Kohberger was miles away from old Moscow, Idaho, the night the 4 college students were slain in their off-campus house. Now, Mr. Kohberger was out driving in the early morning hours of November 13th of 2022, as he often did, to hike and run and or see the moon and the stars, according to the most recent filing that was submitted late yesterday afternoon. The notice provides as well that he, Bryan Kohberger, drove throughout the area south of Pullman, Washington, west of Moscow, Idaho, including Wewanee Park. Well, Way Park is roughly a 40-minute drive from the murder scene. Now, the defense claimed that Bryan Kohberger, given his grueling academic schedule, forced him to not only cut down on the time he spent hiking and running, but also to indulge in outdoor hobbies at night. So the expert witness will be called to testify that cell phone data will show, and their expert will testify to that Kohberger's mobile device was south of Pullman, Washington, and west of Moscow, Idaho on November 13th of 2022, and that Bryan Kohberger's mobile device did not travel east on the Moscow-Pullman Highway in the early morning hours of November 13th, and thus could not be the vehicle captured on the video along the Moscow-Pullman Highway near Floyd's cannabis shop, according to the defense. Now, as you may recall, prosecutors have claimed that Kohberger's Hyundai Elantra was the car that was on the video driving by the student's Moscow home at least 4 times on the morning of the murders, and investigators have also alleged that Mr. Kohberger's phone pinged in the area around the home that morning. Now, the defense team has long claimed that Mr. Kohberger was out driving alone on the night of the murders, but they had basically not given specifics. Now, whether they didn't know it or they needed the backup data to do it, well, there you go. They've got it. Anyway, his attorneys have emphasized that they have more details on Mr. Kohberger's whereabouts on the night of the murder, but threatened to hold the information until the state shared more of their discovery, as they have previously requested. So they also stated, if not disclosed, cell phone tower expert Sly Ray's testimony will also reveal that critical exculpatory evidence further corroborating Mr. Kohberger's alibi was either not preserved or has been withheld. Now, Mr. Kohberger's allegedly broke into the off-campus house about 4 a.m. and then allegedly stabbed the 4 friends to death. And at the time of the killing, like I said, Mr. Kohberger was a criminology student at the Washington State University in Pullman, Washington, which is about 9 miles west of Moscow, Idaho. And obviously after the manhunt, Mr. Kohberger was arrested on December 30th during a raid at the family house in Pennsylvania. And coincidentally, they had the white Hyundai Elantra that they thought that they were looking for. So now that the defense has given their alibi, it is somewhat interesting because they are using the same data that would have been produced to the prosecution early on in this case. Now, there would have been some refinement done, I'm sure, but it's still the same data. So, who is not correct in their data analysis? That's what this is going to come down to. Once again, this case seems like it will come down to the battle of the experts. My expert says you were near the house. Well, my expert says you were out driving around and you weren't near the house. And then they're going to have DNA. Now, obviously the DNA, and having tried many a case with DNA evidence, my experience is a jury wants some explanation as to how that person's DNA got there if you're saying it wasn't you. That's what the defense is going to have to come up with and explain. But as we've talked about in the last couple of weeks, a lot of that DNA sometimes is not exactly what it appears to be. Yes, it may be DNA, but at what levels of DNA? There may be very small amounts. It could be overwhelming amounts. We don't know that. But to say, oh, it's there, but how much was there and how it could have got there? And unless the prosecution can show that Bryan Kohberger purchased this Marine Corps K-bar knife, going to have some explaining to do. I'm sure the prosecution thinks they have some way of explaining that, obviously, because they filed charges. Now it's up to the defense, obviously, to hold the government to that burden of proof. And the question is, if his cell phone data truly states that he was not near that house on the night of the murders, somebody's interpreting or misinterpreting the data one way or another. So the next motion hearing is now set for May 14th. The judge is still considering the change of venue motion, and the defense is still seeking further discovery from the prosecution. Next, I told you this was going to happen, and yes, people mocked me, and they said, Scott, we needed justice. We needed justice, and doesn't this feel good? And I said, just wait. Just because this one prosecutor did it, and they succeeded in the Crumley case, guess what? Now we got another prosecutor doing it. And next time they could be coming for you. So the Virginia prosecutors noted Thursday that they will be pursuing the case against a former assistant principal indicted on a felony child neglect charge at the elementary school where a 6-year-old shot a teacher last year. and suggested others could be charged in the investigation as the investigation continues. Now, a day after the special grand jury report outlining the case against ex-administrator Ebony Parker was made public, the Commonwealth's Attorney General Howard Gwynne told reporters that he was troubled by the findings and believes the charge is warranted. He added that he had never brought a charge against a school administrator or heard of it being done as it relates to this type of case, but we go where the facts lead us, he said. Now, the shooting at the Rich Neck Elementary School in Newport News, Virginia on January 6th of 2023 obviously was big news, and it brought to the attention the school safety, and it stunned the community when police announced that the child's actions appeared to be intentional. Now, obviously, it's rare to be for charges to be brought against parents, administrators, or other adults when a child commits gun violence, not only at school, but anywhere else. But some people are suggesting that the recent involuntary manslaughter trials of the Michigan parents of a teenage school shooter who killed 4 classmates, and where the parents were, for the first time ever, held responsible for a mass shooting committed by the child, set that legal precedent so that now other prosecutors can go forward. So the case in Newport News, a 6-year-old student who was never named used a 9mm handgun to shoot his teacher, Abigail Zwerner, while she sat at a reading table in the first grade classroom. She was injured but survived and managed to escort the class of about 15 students to safety. On the day of the shooting, Parker, Rich Neck's assistant principal at the time, was made aware by other staff and students on 4 occasions that the child might be a potentially dangerous threat, according to the grand jury report. Anyway, Parker's lack of response and initiative, given the seriousness of the information she had that she received on January 6th, is shocking, the report notes, adding that it was an avoidable situation. Now, Parker, who happens to have a PhD in education, resigned in the wake of the shooting and now has been charged with 8 counts of felony child abuse, each one representing the number of bullets that the boy had in the gun. Well, she appeared in a hearing the other day with her attorney, and the matter has been set next month before a trial date will be set. She faces up to 5 years for each of the counts. 8 counts times 5, 40 years. Really? How symbolic. See, now we're getting into symbolism. 1 count for each bullet in the gun, ladies and gentlemen. My goodness. Why not somebody just have the gun, just charge them all with attempted murder because they have 15 rounds in the gun? This is where it's going, ladies and gentlemen. And people said, oh, Scott, you don't know what you're talking about. The Crumley case is different. They had so much information. Why don't you just shut up and go along with everybody else? Because it makes us all feel so good that we have justice. And, you know, Ethan Crumley is going to spend the rest of his life in prison, but those parents are evil, bad persons. Where does it stop, ladies and gentlemen? Why stop at the assistant principal? Why not the teacher? Why didn't she spot this early on, right? Maybe she could almost be complicit, at least reduce any exposure on the civil side. Why didn't she notice the danger? How about the whole school? Maybe the lady working in the cafeteria as well. I mean, she probably came in contact with the kid and she did nothing. You see why it's a dangerous precedent, ladies and gentlemen? When you start getting into feelings in criminal cases and you get out of a true mens rea, what somebody knowingly did, what you can prove, not a negligence standard, which is you should have known. You should know what a reasonable person would have done. Yeah, we don't really do that in the criminal justice system, but now I guess it's acceptable because it makes everybody feel really good. Now remember, the mom in this particular case, they didn't charge her with this neglect in state court. No. They charged her with obtaining a gun because she was addicted to marijuana when she bought the gum, and she lied on the little forms. Think about it, ladies and gentlemen. What do they say? Show me the man, I'll show you the crime. They can get any one of you or any of us as long as they decide that day, I pick you. You think the law should be specific, what's strictly prohibited, and the mental state required. Just something to think about.